Greetings, fellow workers. Welcome to the third and final installment of this webinar series on the impact of recent NLRB decisions on labor organizing. My name is Todd Vachon. I'm an assistant professor of labor studies and employment relations at Rutgers University, and I'm the director of the Labor Education Action Research Network, or LEARN. On behalf of Rutgers LEARN, the Scontras Center at the University of Southern Maine, and the CUNY School of Labor and Urban Studies, it's my great pleasure to welcome you to tonight's program, which, like the previous two sessions, has been developed in partnership between our three great labor education programs. Tonight's webinar will be facilitated by Eric Blanc. Eric is an assistant professor of labor studies and employment relations at Rutgers. He researches new workplace organizing, digital labor activism, strikes, and working class politics, and he has published extensively on this topic. His forthcoming book, DIY Unionism: How Bottom-Up Organizing, Digital Tools, and Young Risk-Taking Leaders Are Revitalizing Labor, analyzes the growth of worker-to-worker organizing in the U.S. since early 2020. Eric is also a longtime organizer and trainer in the Emergency Workplace Organizing Committee, EWOC. So without further ado, I will turn it over to Eric to introduce our panelists and facilitate tonight's discussion. Eric?
Thanks, Todd. And hi, everybody. It's great to see so many folks out there. And, you know, it's an exciting time in the labor movement. You might have seen some big victories yesterday at Starbucks, at UAW. And so it's a good moment to be talking about the way forward and how workers and unions can seize this moment. So with no further ado, I'm going to introduce our first speaker, who's Teresa. We're very sort of excited to have her here. She's the regional director for the NLRB's Brooklyn, New York office, which is Region 29. She's worked for the NLRB for over 20 years. And prior to working for the board, Teresa worked for various unions and research organizations. She also works as an adjunct instructor for Rutgers University Labor Studies and Employment Relations program, where I'm also at. So I'm going to give it to Teresa. I'm going to explain the rest of the program afterwards. But for now, the most important thing is Teresa's going to speak for 15 minutes. Then we're going to have 15 minutes for Q&A. You're going to be able to use the Q&A function of Zoom to submit your questions. And then I'll be floating some of them to Teresa. So Teresa, the floor is yours.
All right, thanks, Eric. And thank you, everybody, for inviting me. I have 15 minutes, so I'm going to just get to it. So I have been invited to explain the very basics of Cemex. It's a new decision that was issued by the board that establishes a new framework for bargaining. I will then answer some questions. I will leave. Just so you know, when I answer questions, I can't give legal advice. So first slide, please. I'm going to first explain the whys of Cemex. So this board issued Cemex for a couple of reasons. I think it's important for us to understand the why of it in order to determine whether it's really working and it's doing the thing that the board wants it to do. So the first thing that the board does in its decision is it says, well, why are we doing this? And it goes back to the fundamentals. It goes to Section 1, I'm sorry, of the Act, the preamble, and cites that one of the purposes of the Act is to encourage the practice of collective bargaining and to make sure that employees have free choice, the full freedom of association and self-organization. So I'm just going to use free choice. So collective bargaining, free choice, is motivating the board to return and consider whether its framework for getting to a union and to getting to collective bargaining is actually working. And then it goes in and it determines that no, indeed, it's not working. The current framework that we've got is not working. So there's a couple of key things that I want to get to and then kind of explain why it's not working. For the most part, it's the framework is disincentivizing, it's delaying, it's deterring, and it's actually giving the employer time for an unfair labor practice. So the key reasons for the failures of the framework, and they hang together, is one, most unions for the board practice is that most unions have to file a petition. Certainly there's always voluntary recognition, which is legitimate, but the board really favors that a union file a petition in order to get to an election and in order to get to the point where it is the representative that will bargain on behalf of employees who have selected it under conditions of free choice. That petition, as I think in prior seminars, prior webinars, automatically sort of puts time on the table. So there are all these procedures and time that go with processing the petition. And the board said that during, their experience in practice, their experience has indicated that this time is usually a time where employers, commit unfair labor practices in an attempt to put their thumb on the scale in order to make it so that employee free choice isn't really happening, right? So through threats and firings and all of that other kind of stuff. But the real issue, besides that basic structure, one of the other problems is a remedy, right? So the remedy that the board looks at is usually if a union has to go through a petition to get to an election, to get to the chance to become the representative. And along the way, there's all this time, and along the way, there are all these opportunities for the employer to commit unfair labor practices. The other problem with the framework is that the remedy for getting back to a free and fair election was falling far short. The remedy was usually rerun the election, attempt to restore the status quo, attempt to restore the conditions, the free conditions for a free and fair election, and sometimes something called a Gissel bargaining order. So next slide. So the board says, okay, we're going to get rid of this framework and we're going to come up with a new framework, one that will no longer serve as no longer create an incentive structure for employers or other parties. Sometimes unions do this, but employers to delay so that they can they can commit unfair labor practices so that by the time you finally get to an election, there's a loss of support, and the only remedy is to rerun an election or perhaps get a Gissel bargaining order. So what the board does is creates this new framework. So the new framework, the key features, and I'm going to kind of go through it piece by piece here. Some of the key features of this framework are that, number one, the board actually decides that the starting point, which is, I guess if you can see my cursor here, which is this frame right up here, this box right here, the starting point for a union is no longer the petition, but the practice that a lot of unions have already got in place and have been in place for a long time. If you know your labor history, this is the way it usually works. But it is get a majority, demand recognition. You don't have to come to the board. So what the board does is it institutionalizes this, that this is the true start for a union's demand for recognition, for the chance for employees to get their opportunity to have a union represent them. So that's the starting point, no longer the petition. However, and then once that happens, then there's a 2 weeks, and I'll get into this a little bit more, but there's 2 weeks, and then it's on the employer. I wouldn't call it a burden, but I think for simplicity, the burden shifts to the employer to file a petition to test the union's majority. So now it's the employer that starts the petition clock, not the union, right? The union is out here doing voluntary recognition, getting majority. So that's one other feature. And then one other feature of the new framework before I get into the details, another feature of the new framework is it shifts the remedy. So the remedy is no longer if you commit an unfair labor practice and poison the well such that an election is impossible. And if an election happened and the union lost, the remedy is no longer, well, we've got to run a new election. The remedy is no longer maybe this Gissel bargaining order. Rather, the remedy is something called the Cemex bargaining order. All right, so those are the 3 features that define the new framework. So I'd like to just go through some of the basics with you on these features. So next slide. So the starting point now And it's not that this is like a new starting point that unions have to create. Unions have known how to do this for a long time, but now the board institutionalizes this as a starting point. So the starting point is the demand for recognition and getting majority support. So here I'll just explain some details of what that means. Usually majority support from our perspective of the board, it's usually like an authorization cards or a petition. It's got to be signed, dated by the employee who wants to authorize the union to represent them. Good majority support or a good showing also records the employer's name, maybe job classification, job location. Heads up, there's a good practice, and that is to authenticate the showing of interest. Somebody has to say, yep, I was there, I saw it happen, or maybe initial it, whoever's collecting the showing of interest. Once that happens, and it's 50% of whatever group of employees you think is a unit, then the demand for recognition happens, right? That demand can be oral, in writing. It just needs to clearly communicate that we're looking to seek to represent this group of workers, this unit. So that's the start, right? So that is, the union doesn't have to come and file a petition, but this starts a clock now. And that clock is 2 weeks. So next slide. The demand for recognition now starts a clock, and it is 2 weeks to determine whether this recognition and this union is going to come in through petitions or there's going to be voluntary recognition. These two boxes here, I'm not sure if you can see my cursor up in the top right-hand corner. This is the usual voluntary recognition, which is demand for recognition happens, and then the employer voluntarily recognizes, and then bargaining starts, and hopefully a contract occurs. But that's not the way it happens under Cemex. So Cemex has now put the burden on the employer to file the petition. So if the employer thinks that the union doesn't have a majority, the employer can file an RM petition. And an RM petition is like, the employer has a good faith doubt that you don't have a majority. That RM petition has to state the group of workers that the union is looking to represent, right? Because the whole purpose of that RM petition is to simply test the majority, right? So here, the assumption is, employer, if you have a true good faith that this union does not have a majority, you can file a petition and we will run an election for you, right? If an employer wants to contest the unit and say that unit is inappropriate. So for example, a union comes in and files a unit for waitresses and bussers, but doesn't file a petition for the cooks or back of the house. The employer can say, actually, I want to test that unit, so I'm going to file another RM petition to say that unit's wrong. So an employer has to use one petition to test the majority, but another type of petition, another RM petition to test the unit. So, but it's the burden's on the employer to start the petition process. Now, a union can, of course, always file a petition if they want to choose that route. If they have also made a demand for recognition in the background, and just so you know, the demand for recognition with a majority support, that is the only thing that's going to get you a Cemex bargaining order, which I will explain a little bit later. But when a union files the RC petition, a very good practice is to fill out box 7A. 7A says we have demanded recognition, right? We had a majority and we made a demand for recognition. So you put that on the petition. But an RC petition, that's if the union wants to do that. All right, next slide. Okay, so we're in the new Cemex area. So these boxes that have dashes around them, those boxes are the sort of new Cemex territory of how a union gets to the bargaining order. So in this box, say you made a demand for recognition, and the employer has not filed a petition, or you make a demand for recognition and the employer files an RM petition to test your majority or perhaps test your unit. So if that's the case, great, fine, that's how it's supposed to work. But in that time, right? Remember, the petition sets up all of this additional time. And hopefully every party's using that time for good faith reasons, but experience shows that that does not happen all the time. If during that time the employer starts to commit unfair labor practices, threats, firing, threat of job relocation, surveillance, interrogation, all of those things that tend to terrify workers so that they don't really want to vote for the union anymore, they become scared. If the employer starts to do that, well, then we've got a whole other remedy. So I'll explain that in a second. So the type of remedy that occurs, so the union, if there are unfair labor practices filed after this petition or after the demand for recognition, the union will file an unfair labor practice charge. Regional director and the office will investigate. And then if there's merit to the charges, instead of ordering a new election, right, or instead of ordering maybe one day a Gissel bargaining order, we'll order a Cemex recognition and bargaining. And what occurs is that the employer forgoes its right to have an election to test the majority status, because the argument is that the ULPs have so tainted the situation that it's impossible. So why, under the new Cemex framework, why would the board, whose fundamental job is to promote collective bargaining and free choice, give the employer another bite at the apple? It's like you have foregone your right to have an election, and we have this whole other program, this whole other system, which is majority status and a demand for recognition to assign bargaining privileges to the union, or bargaining power to the union. So employer, file the petition, do it in good faith. But if you commit unfair labor practices that they're meritorious and that would set aside an election, you don't get another shot at an election, right? So the board's no longer going to give this employer another shot at the election. Okay, but there's another type of unfair labor practice besides the threats, besides the firing your lead organizers, all of that. Another one that occurs, and this is the one that comes from, there's no petition on deck, right? The union has demanded recognition. The employer did not file a petition within 2 weeks to test the majority status, but still doesn't recognize the union, right? So you demanded recognition, the employer's like, doesn't say anything, or says, no help, no way in hell, I'm not doing any of this. When that happens, then the union files something called an 8A5 unfair labor practice. And in that case, the investigation goes, well, do you have a majority? And did you make a demand for recognition? And is this a unit that we would certify? And if those three factors occur, then it's a violation of 8A5 and it's a Cemex bargaining order. All right, next slide. All right, so yeah, I just went through that. This is no petition, union files the 8A5. So again, these are two types of unfair labor practices that set up a Cemex bargaining order. And the Cemex bargaining order, if a petition is on deck, the region and we've got merit on unfair labor practices that, like threats, firing, discharges, all of that, or a refusal to recognize and bargain, the regional director will issue a complaint, seek a bargaining order, and will dismiss any petition that's on deck. All right, next slide. That is generally the framework. Heads up, if you need to learn more about the Cemex framework, you can find it at www.nlrb.gov. There is under publications, you'll find General Counsel's resources on Cemex, which has a whole bunch of stuff. And I can get those links to the team. So you can go ahead and stop the slides, and I'll have some final remarks. I've heard from people, even from people inside my own region, which is this idea that Cemex is a way to increase the speed. It's like faster, and in part it is faster. There's a number of areas where unions and workers can get to the table faster. But I think that the primary reason for Cemex is deterrence. to ensure that the union or the employer or parties are not committing unfair labor practices, because the real muscle of Cemex is the remedy, the bargaining order. If any employer or any party wants to litigate anything, well, litigation just takes time. So that's it. Did I do my 15 minutes?
You did. So well, let's jump into the questions.
Right.
So, and folks, please put your questions. We've gotten a good amount already, but please put in more to the Q&A. I'm going to start off with one, which is prior to this decision, there was a lot of discussion around Joy Silk, and I know that this has some sort of relationship, and maybe you could clarify both what Joy Silk is and was. And then there were some people who were disappointed that it didn't go all the way towards Joy Silk. So could you clarify a little bit more of what Joy Silk was, and how much of the way this got us in that direction? And then if it's something that can be talked about, why the decision wasn't to sort of go back to Joy Silk fully?
Right. So I don't know how good of an answer I will have for you. I will try my best on this one. So one of the things, so I'll start here. Joy Silk, I think, got us to recognition and bargaining in a lot easier method and manner. It didn't have this file an RM petition, do all of this other stuff. So that's generally where I'll start. So what I will do is explain what the board was wrestling with in Cemex. So the board's got a couple of things that it has to ensure, because there's pressure on, you need to have an election. And what the board did, and I'm sure that I'll get you a better answer later, but what the board did that was really kind of ingenious, that may not have gotten us back to Joy Silk, but I think we call it Joy Satin, like Cemex is Joy Satin. What the board did is it turned the RM petition sort of on its head, right? Customarily, an employer can file a petition to test the majority status of a unit or of a union. And that usually happens like when somebody's trying to decertify a union. What the board did is it put that RM petition and that notion of the good faith doubt on the employer to file to test the majority. And the board, I believe, was like dealing with the problem of denying elections absolutely. I think that's one of the reasons they didn't go back to Joy Silk. That's an unsatisfying answer, and I'll get a better one to you.
Okay, thanks, Teresa. We've got a few other questions. One was, can you go over the differences between a Cemex bargaining order and then the other bargaining orders that you mentioned? This was somebody said they didn't catch the first one, and if you could just explain maybe the differences, and then for maybe people don't actually know what a bargaining order does. You mentioned it briefly, but it'd be worth maybe just explaining a little bit more for maybe people who have less experience with that, because it seems like that is ultimately one of the crucial aspects of this decision, is that makes bargaining orders, as far as I understand, probably more likely, or at least the threat of them significantly more likely.
Right.
So can you talk about those differences, and then again, just what exactly a bargaining order will do in practice and in theory?
Okay, sure. So a bargaining order in general means that the union doesn't, so it's usually a recognition and bargaining order. Usually the way a union will get recognition is by proving a majority status, right? Because that's the whole part of the act, is that employees get to choose, have a free choice in whether they want a representative or not. And if they want a representative, which representative? So it's that idea of free choice in the workplace to get your representative. Usual process is what was it? Demand for recognition or an election. An employer can taint the situation or create a workplace where that free choice is impossible. And in those cases, then no election for you. All we have to prove is at some point, like there was free choice somewhere at some point. And at that point, then the board will order a remedy that tells the employer that you have to sit down and recognize and bargain with the union. right? So it's no election for you. Now it's time to bargain, right? And then all of the other additional like responsibilities that the employer has, bargain in good faith, meet, et cetera. So the difference between a Cemex bargaining order and a GISL bargaining order is the time, is the activity that the order attaches itself to, right? So with Cemex, it is looking to take a bargaining order, which denies an employer a chance at an election, take that bargaining order and aim it at the activity that occurs prior to an election, rather than down the road at a future point. So the order itself isn't different. It's where it attaches itself to. Is that okay?
Great. Yeah, that makes sense. And then just again to clarify for the sort of folks who are less clear on this, again, the bargaining order, it seems like one of the big steps then is this it skips over the whole election process, which is right with delay tactics from employers oftentimes. So that seems like another way of speeding up the process. But again, it is, in case anyone is wondering, it's as far as my understanding is, it's still relatively limited as far as the sticks that the board has to actually enforce employers to bargain. So a bargaining order doesn't, maybe as the name suggests, actually in practice currently ensure that the employer bargains.
Right, I get you.
So maybe you could, if you could speak to that a little bit, because there might be confusion out there for people who don't understand.
Yeah, so a bargaining order of the board, the National Labor Relations Act, the law does not require the two parties to reach an agreement, right? Because the goal is, I don't want to sit and bargain for years and years and years and years. So bargaining is really like getting to the table to bargain is a step in the right direction. But the bargaining order isn't then you have a contract. You still have to like go through the legal process, but also the like off like table, the economic power, the mobilizing, the public power, everything that got you to the table. Do not leave it behind just because you've got a bargaining order, right? The bargaining order gets you to the table without an election. How you get the employer to agree to your terms and to bargain in good faith. So there's some law that we use to decide whether an employer is bargaining in good faith. But then there's the power that that unions and workers have that give the extra push. That does not change at all with the Cemex bargaining order.
Just wanted to clarify that in case anybody was perhaps overly optimistic about what this entails. We have another important question, which is, in the current framework, bargaining unit size disputes often can slow things down following voluntary recognition before negotiating a first contract. Are there any trade-offs for unions in the new framework in trying to avoid a time-consuming dispute over unit size? So I guess the question is, how does this new framework relate to the kind of always tricky question of bargaining over unit size? Because as who maybe aren't as experienced, oftentimes this is another place where employers drag it out. And so it's hard to know how much to fight over this because sometimes unions will concede a smaller bargaining unit size for the sake of going quicker. How does this change any of these calculations, if at all?
Right. I think that so when I answer, I usually will answer in terms of like new board law and like your own leverage, and union and worker decisions. So on the board side, the Cemex decision doesn't necessarily help you out there. It's the new rules that help you out. So the new R case rules that preclude the employer from that preclude parties from raising that. We have a tool that allows the regional director to exclude certain issues from going to hearing. So for those of you who don't understand here, so an employer can say, all right, here's a petition, but that unit's all wrong. That group of workers just isn't going to work. It needs to either be bigger or smaller or comprised of a different group of people, but they can like hit a union on its unit composition or unit size or unit location. So it can like make those kinds of arguments. The new rules allow the regional director to what is it? I forget the term, but to exclude those things that do not, and I'm sorry to use so much legal jargon, those things that don't actually genuinely represent a question concerning representation. So what does that mean? If the employer comes in and says, okay, you've got a unit of 100 nurses, we think 10 of them are supervisors, right? So a regional director can say, that's not going to hearing. So it's a way to limit the employer's ability, the new rules, the way to limit the employer's ability to like stack a hearing with nonsense. So the new rules are the place where you would find the power to like kind of limit the employer's ability to run out the clock on a hearing. Does that make sense?
Okay. Yeah, thanks. We have time, I think, just maybe for one more question. So Linda asks, how will the NLRB decide that a ULP has been committed in order for a bargaining order to be implemented? ULPs still take years to be decided, she says, and the NLRB is not receiving a bigger budget to change that. So there's a few different related things there, ULP, and then how does this maybe relate to the underfunding of the NLRB?
All right, yeah. So I mean, obviously, I know General Counsel's been out there. The board members have been out there. Just and it's broadly in the news that we just need more staff. From Region 29's perspective, we've lost 40% of our staff. Haven't hired anybody. Just got to hire one new person in the last 10, 12 years. At the regional level, we look at him like he's a toddler and we can't stop staring at the new face. But anyway, so with the speed, so how quickly can we get to the finding of an unfair labor practice? A Cemex type of charge would like rise to the top. So one of the things that I know that all regions are doing is they're starting to triage. So in the past regions, there was a bit of a triaging like matrix that we would use, like some would go faster, some would go less. But we are now triaging. So some cases that just don't have discharges in a Cemex order, those just sort of like linger. So a Cemex type of case we would devote more resources to that to make sure it moves as quickly as possible. But yeah, legal procedures.
That's really interesting. I had no idea about that. That actually seems quite significant. I'm just going to flag that seems for people to know. Because that just
each region is trying to come up with methods of triaging.
Great.
Like every day is like the ER room.
Well, Teresa, that's all the time we have for this section. But I just want to say we really appreciate you taking the time to be here, and I'm sure everyone out there is giving a round of applause. And so we're gonna do the round of applause out there. And I know you have to run and excuse yourself at this point, but yeah, I just want to thank you again for being here and thank you for your work.
All right. Thanks, everybody. Have a good conversation. Thanks for inviting me.
Teresa can't be here. I think for legal reasons, for when we get into the nitty-gritty of how our side wins, is my understanding. There's some procedure. So she's bowing out. But now we have a very esteemed guests to talk, from the labor side of things, both organizing and the legal side of what does this mean in practice and strategically for labor. So I want to introduce our next guests. We have, skipping past, we have Ray Heineman, a member of Kroll, Heineman, Ptasiewicz, and Parsons law firm, where he concentrates his practice in labor and employment law on behalf of unions and Taft-Hartley benefit funds. He regularly appears on behalf of labor unions before the NLRB, state administrative agencies, as well as in collective bargaining negotiations on behalf of unions in a wide range of different industries. So we thank Ray for being here. And the second sort of panelist / speaker is Tony Ruiz, who's a third-generation union worker and leader dating back to his grandfather's time leading the hospitality union in Havana, Cuba. Tony's been a union member since the age of 18, working his way up through various roles within his union. He spent the last 5 years as an organizer in the Pacific Northwest, assisting IBEW locals. He's also a volunteer organizer with EWOC, Emergency Workplace Organizing Committee, since its beginning. So a round of applause out there for Ray and Tony. The way this is gonna run is we have until 8:30 Eastern. So we have a little bit less than an hour, about 15 minutes. And the framework is I'm gonna ask a few questions we're gonna have a facilitated discussion, and then we're gonna open up to Q&A from all of you. So start thinking, and you can put in the questions again as the discussion is going, and then we'll get to that around 25 minutes, halfway through. So, okay, with no further ado, first starting question. How, if at all, does this change organizing? What does this mean for organizing unions strategically? What are some of the big takeaways? Maybe we can start with that and we can get into some nitty-gritty. But I guess my question for both of you is, if you had to highlight one or two major differences that unions should sort of adjust because of this new framework, what would they be? Okay, so who's going to start us off, Tony or Ray?
Okay, so I mean, one of the things that traditionally has been problematic is the delay. You go through the organizing process, you get your support, and then you file your petition, and the employer then starts this organized campaign and starts your support can dissipate. And once you start getting heavy unfair labor practices, it dissipates more. And you get the delay in the election process, you get to your election, and now you're in legal limbo for a while. What I think this process can do is it can disincentivize the commission of unfair labor practices. So what I've been seeing, we've been seeing increases in the RM petition. This will work if at the same time we're seeing increases in the RMs and our own petitions, if we also see a fall off in unfair practices. So if employers are being counseled to avoid the unfair labor practices because they can end up in the bargaining order. So I think it's very important to monitor the unfair practices and monitoring, keeping your support for getting statements from workers, monitoring to see when to shift the Cemex. So I like the idea of filing this demand under Cemex at the same time you file your petition, because that way you're moving the process along at your pace, and hopefully you're disincentivizing the unfair practices, which I think increases your chance of success at the board to get an election victory. Failing that, now you can rely on the Cemex bargaining order, hopefully prior to your dissipation of any support. Like under Gissel, what's been very frustrating is you start to get these heavy unfair practices, and now you have to wait for all these hoops, and it can take 1.5 years to get to an administrative law judge's decision. So the hope is by disincentivizing the unfair practices, you avoid the serious ones that dissipate you. So once you get your bargaining order, you're at a position of greater strength. So that's kind of what I see, on a macro level, that this decision is accomplishing. So.
Yeah, I kind of agree with you there, Ray. Look at it from two perspectives, right? You want to look at your filing tactics and then your actually organizing tactics. What's changed? How you want to approach this? And you're right. For me, if I'm filing right now, just currently with the Cemex process and how it's taking so long, I'll just give you an example. I got a Cemex order on a campaign I was working on December 15th. We got the bargaining order. It's still pending litigation, and we're coming up on 2.5 months. We're actually just going to go ahead and file a new RC petition on the campaign because all of the employees are gung-ho and ready to move forward, and we have plenty of support to file a petition again, because it's been over 1 year since the elections happened and it was shut down. So, I think it's a good tool, but it's delayed right now. The process is taking too long. So when I personally I'm of the opinion when we're filing, or presenting a demand of recognition, we're also filing an RC petition. We're giving the employer the opportunity to still voluntarily recognize, saying we will rescind our RC petition if you voluntarily recognize. So there's still that opportunity there. But with the new RC petition rules and timelines, it's a lot quicker. I mean, we're going to get through the process quicker than Cemex is. Now, maybe eventually, as they work out the kinks and potentially get some more funding and some more staff, that'll change. But ultimately, Cemex right now is just another tool in the toolbox. but it's not, a magic wand, so to speak. It's not doing everything for us. So that's kind of strategically when we're filing petitions, that's how I'm approaching them. And then second, if you look at how you're organizing, what you're doing differently when you're talking to workers, I'd say I am spending a little bit more time with our organizing committees, really digging into what unfair labor practices are, kind of some nuances of them, not just the big ones anymore, kind of, some of the smaller ones, and really digging into any policies and handbooks the employers might have that would also be considered unfair labor practices. Just policies too broad that may limit an employee's right to engage in protected activities. So those are a couple things I've switched to or really focused on in my organizing campaigns. And then finally, really hammering on how folks need to really focus on documenting everything, every aspect of their day at work. We've got these great smartphones now, where when I was first getting involved in union organizing, we didn't have smartphones. So everything was pen and paper. Now you've got a plethora of apps that you can use that'll just on a daily log everything that's happening, every interaction you have with management, including what they're wearing, what the weather's like, what they said, how you felt, and just those have been really, really helpful in any unfair labor practice hearings and investigations. That's kind of what's changed for me.
Okay, great. So there's a lot there, and I kind of want to maybe dig into a little bit, but some of these a little bit more. One of them is, Tony, and I'm wondering if Ray, if you could speak to this, and you can speak to how much of this is your experience, if you know what other unions are. If I understood correctly, what you're saying is really interesting, is that you've actually found it counter to what maybe the intent of Cemex is actually been slower than the older sort of standard, representative election RC. Did I understand you correctly? That actually currently you found that to be, it hasn't been a quicker process yet. If maybe I misunderstood, but could you speak a little bit?
No,
more to
Eddie,
that?
I think you're head on. I'm not in.
And then so
in
the
her-
question is, could you speak
Yeah.
more to that? And then Ray, I'm wondering if it jives with your experience, or because maybe there's it might have to do with the region, it might have to do with a variety of factors. So this is an important thing.
Yeah.
Go
I'll
ahead.
probably say I'm based out of Portland, Oregon, and I support Oregon and Washington. So Region 19 and Subregion 36. Those are the areas where I'm at. So I can't speak to the other subregions, right? But if you're with any experienced organizer in your area, they should have a pretty good idea of what timelines are for your region's board. But just looking at knowing the staffing levels and the budgets of the board as a whole, I don't know if timelines are much different anywhere else, because when you get the regional director's decision to a bargaining order, so to speak, the employers are going to litigate that almost every time. I don't know anyone that's just going to accept it. So they're going to appeal, then it's going to go to advice, then it's going to go to the board. So there's just so many different, and Ray, maybe you can clarify that part for me, but there's just so many different steps that the employer can take to delay that Cemex actual bargaining order going through. But who knows, maybe that'll clear up in the near future.
So,
Ray.
sure.
Go ahead.
The Cemex bargaining order, remember, you make your demand, and then if you just rely on Cemex, you wait 2 weeks. So if you're lucky enough not to have gotten hit with unfair practices, now 2 weeks, we start the unfair practice process of investigation, complaint determination, authorization for and now you're drifting. Under the board's election rules, and I don't have them in front of me, but if you file your petition the same day you make your Cemex bargaining order, or your Cemex bargaining demand, 14 days later, you're already in the process of getting to an election. You're going to have an election in a couple of weeks after that. So 28 days after you filed, now you got an election. If you purely use Cemex, you're kind of drifting off, and the investigations, I have a Cemex case that was filed in early fall, and it's still, the region's moving it. I keep being told, but there's a lot there. There's a lot, and the thing is drifting, and you heard the regional director from Brooklyn. So to me, you don't want to just rely on Cemex. To me, it's a tool. you combine it with the filing of the petition, because think of it. If you just use Cemex, you're filing a charge 2 weeks later. Under the board's rules, you're actually engaging in setting up your election. Under Cemex, you go through at best a 30-day, 45-day investigation, which I haven't seen in years. Under the petition rule, you're at an election in 15 days. You're getting an election before you're getting a regional determination on your practice. So to me, it's combining it. It's not that Cemex delays the process. It's Cemex is a tool to assist in the process. So if your election runs into problems, now you start getting heavy unfair labor practices. In the past, you would pull those, file your GISL bargain, and now you have to prove substantial serious unfair practices. You got to focus on the future. That changes under Cemex. So your case is a lot simpler to get your bargaining order if that's where you get pushed to. And the employers know that. And that's why I say, hopefully, it'll be a disincentive for employers to interfere with elections and unfair practices. So that's where I see the true benefit of Cemex. So.
Yeah, no, so that's very helpful. And so again, so there's really no reason not to sort of use both tracks simultaneously. And the real comparison then is basically between Cemex and GISL bargain, which was much harder to get. And so this is the gist of it, as far as I understand, is really this should, even if it's slow, you know, compared to what we would want it to be, it still hopefully will be quicker than what it took to get a GISL bargaining order, which, as far as I understand, were relatively rare because it was so labor intensive to get to. So I think that sounds right to me. What I'd like to hear a little bit more from is just in practice, what can you give any more examples of from your experience of what this has looked like since it was instituted? As far as have you heard of people getting bargaining orders? Have we gotten to that process? Do you know of any other experiences? Just shop a little bit more about what this has looked like on the ground, either in your region or from unions that you've worked with.
I'll go first. In my area, and even talking with the board agent that was just on earlier, between the two of us, I have not seen any Cemex bargaining order come to fruition yet. They're all still being litigated. And the one I was working on, like I said, came out very, very shortly after the Cemex decision was made. Like the ruling was certified, and we got a decision December 15th on a campaign I was working on, and it's still being litigated right now.
And I think that's the case. This decision came down, I think it was August 28th, 2023. So with the regions backlogged, if you will, I mean, we're not seeing them. I haven't gotten to the table yet. I mean, there is the possibility of remedies for past. So a retroactive application of Cemex. So I haven't had a case where I'm in that you have that opportunity, because think of it, if you have a case that's in litigation, you would have had the demand bargaining, then had the unfair practices and the refusal to bargain. But it's out there, and there are cases that are doing it. I know the NLRB issued, or an ALJ issued, a decision recently in a case up in upstate New York with a cannabis dispensary, retroactively applying Cemex. But I think at the moment, like my experience is, we have cases in the pipeline. So I have one where we filed the petition, we went to an election, lost, and now the region's telling us that Cemex should apply, and they'll be obtaining a bargaining order. I have another one where we didn't get to an election because the employer immediately started committing unfair practices, discharged people. It looked like a GISL case, but we don't need GISL. So we're focusing on the now, and the region is going for authorization of Cemex, of a Cemex bargaining order in that case, and I'm told it'll be down to Washington any day now. So hopefully sooner rather than later. So this is all in progress. So, I mean, the theory is it should speed up the process where there's unfair practices or loss of majority support, and hopefully speed it up enough so when you get to the table, your support's not obliterated. You still have people in the shop you can still put together, reorganize, and then move forward at the table. That's what's so frustrating about Gissel, is you get there a year or 2 years later, and do you have support left? So you're almost a stranger to the workplace then. So hopefully this works.
Great. So it's a little too early to fully tell exactly the timeline on some of this. It seems like we'll have to do a part 2 in half a year or a year to have like a more concrete assessment of the timeline. But we have a question, and I just want to flag people out there. Please start sending in your questions. We haven't gotten too many yet, so I want to encourage you all now to send in your questions. Hopefully you have a lot. We have a question from Brandon in Region 4 of the UAW. Which is to maybe restate one of the things that was mentioned briefly, but I just want to make sure we all get it. And what Brandon asks, he says, Mr. Heineman suggested filing 2 things simultaneously. Can those 2 things be restated? So, Ray, can you go back into and maybe just walk through, just explain a little bit more in detail. When you say you're filing at the same time, what exactly does that entail for people who don't really know what this process looks like?
Okay. So under the board's new election rules, when you file your petition with the NLRB, you also file a petition, a copy of the petition with the employer. So you tell the employer you're filing the petition, you give them the board's election rules, and you say, we filed. And then you tell the board, we've told the employer we filed the petition. And when you file, so that's pure election. So you do it at the same, you're under the rules, you tell the employer you're filing, and then the sped up process results. The employer has to respond, everything gets done quicker than under the old way. My suggestion is when you file the petition in the very same letter, dear employer, we are UAW Region 4. Please be advised, we represent a majority of your production employees at your auto warehouse. We demand recognition. In the interim, please find enclosed our petition filed with the NLRB. And as the regional director suggested, on the NLRB petition, there's a space to check off that you demanded recognition. So my view is combine that letter. That way you're giving it to the employer at the same time as your petition, and you're getting off to the races quickly. So the other way, theoretically, you could do it is deliver your demand letter at the same time and send a second letter to the board, but you're going to send the employer the letter anyway. So it's,
I see. So this is
on how you
might as well do it on the same.
That's kind of my view, and that's what I've done several times now. So it made sense to me. So, and then that way you're taking advantage of both the board's expedited election rules and Cemex, putting them both together, using both tools.
I have a question for Tony, and again, folks, put in your questions to the Q&A box. I'm wondering, Tony, when you're talking to workers, like, does this come up? I wonder, because to me, like, so I'm a labor scholar, and and I'm reading the things. I'm not a legal scholar though, and and so I have sort of like a layperson's understanding of the law, of the labor law. And I find it even like tonight, it's like I'm really have to pay a lot of attention to like follow the details, a lot of acronyms. It can be quite sort of challenging to follow the details. And it can be a little overwhelming. So I'm just wondering on the day-to-day when you are working with an organizing committee, what of this comes up? What of this do you bring up? And what doesn't, what do you not want to bring up? Like, because it's
Sure.
just too in the weeds, and maybe at some point if it becomes relevant. Can you walk me through like just a little bit more concretely, like what from this actually you don't really gonna get into, and what you will, just on like a really like simple conversation having an organizing committee, what from this, if anything, is going to be brought up for them? And you maybe mentioned it before, ULPs and things like that, but can you just maybe walk me through again and walk us through how that would look in your conversations?
Sure. Yeah. I mean, unless specifically asked or talked to, I'm really not bringing up Cemex, right, in an organizing campaign. I will say, however, there's a certain demographic, and tends to be our younger workers, folks associated with like the DSA and other socialist groups. They're a little bit more in the know. They're paying attention to this kind of stuff. So they're bringing it up to me and asking me about this and how this would apply in their situations. And in which case we obviously talk about it. But there are so many different thought processes and tactics and organizing that I'm just really focusing on educating the worker and preparing them for the anti-union campaign the employer is going to throw at them. I don't really get too much into some of the finer details like this, like, you know, so to answer your question, no, unless asked, really, because I don't want, in my opinion, I don't want folks focusing on that. I want them focusing on just, hey, what are your issues, and the fact that your issues are not going to get resolved unless you are able to form a union, and then your employer is going to do everything to talk about everything except for those issues. And I kind of just run my campaigns based on those fundamentals, trying to keep it as simple as possible, because there's so much that can go on with like labor law and things that could happen, right?
Right. And
Does that
I'm
answer your question, I think?
that does answer my question. And I have a specific follow-up question for both Ray and Tony. I'm wondering how you meet people's expectations on this now, because I think that it can be, I've had some organizing conversations where people were like excessively maybe excessively optimistic about how much this would change things, and they're like,
Mhm.
you know, so maybe you know they think it's going to go much quicker, and then it always ends up going slower than you want to you know you would hope. So I'm just, how can you just talk a little bit briefly about how you're talking to people now on the timeline on this, insofar as we still don't know how long it will take? You know, you suggested the difficulties on your end assessing this, you know, because is sort of a new experience. But then when somebody asks you like how long we might expect for a bargaining order to come, what can we tell them right now at this moment?
I don't have a crystal ball, but Ray, maybe you got a better answer. It's an unknown. Right now, it really is an unknown.
It is. So I think when you're, and I agree with Tony, when you're organizing, you're focused on solidarity, keeping people together, moving forward. This is a tool if things start to go south. If you're getting problems, then we're using this. We're using it against a bargaining order, or we did in the past. Hopefully we don't need it. But so that's part of it. I think realistically, and I think once the board gets its triage process up and running and they get staff, we'll start to see these move faster. But I think you're going to still see, in my view, is emphasis on the election process, then this, and then hopefully as the board triages it, we'll get movement a little faster on these cases as they become priorities. The other tool that's out there is the 10J injunction, where you go directly into court to enforce. So my hope is, and you know, in the cases I have right now, we've asked the board to go for 10J injunction, and the regions are requesting 10J injunctions. Now, the legal question out there is how receptive will the courts be to an injunction in these cases? They're supposed to be very deferential, but we're returning partway to Joyce Silk 1949 and a reversal of an old case called Linden Lumber back from the 50s. So that's kind of the question. If we can get 10J injunctions, then I think this process does move a little quicker, because you should be able to get those hopefully within a few months. But we need to really see the board moving these cases as well as all its others at a better pace, because it is frustrating.
So can you speak to that? Because this is one thing that I've always found mysterious is 10J. Whenever 10Js come up, it's like, oh, it's like this very mysterious, amazing thing that somehow sometimes arrives, and we wish they were around more. How does this, everything we were talking about, relate to getting a 10J injunction? And why if this is a, as far as I understand, is actually maybe the strongest tool as far as enforcement to really bring employers to, you know, if not the bargaining table, at least to seriously push them in that direction. Why is it that it's so hard to get a 10J injunction, and how, if at all, does this relate to that?
10J is a tool at the discretion of the board and the general counsel's office. They have to be interested in using it. So the idea is you get your investigation, the region issues a complaint. Oftentimes, I know the board likes to get the trial started, but in certain types of very strategic cases, they will then go into the federal court. It gets the remedy up front before the litigation. So the court evaluates whether the complaint merits a remedy. And they're supposed to be very deferential, but these cases are very strategically placed. So prior to the Obama administration, we were not seeing, 10Js were extremely rare. During the Obama administration, they started to increase the use of 10Js across a wider range, things like initial organizing drives, initial contracts, so trying to speed up the remedy. During the Trump administration, everything went blank. We didn't see them anymore, and now we're seeing them again, but we're seeing them in the context. We have a general counsel that's willing to go in and seek these injunctions, but we're also seeing less staff, less ability to get the cases filed. And people like Tony and I keep filing more charges and organizing more workers, which you're teaching everybody to do. So, the process is getting jammed up, although we now have a general counsel that's willing to move forward on getting these injunctions. So you go into court, and the judge theoretically is supposed to look at the complaint, evaluate the complaint, maybe look at the first day of the administrative law judge's trial, see if there's enough there, and then issue your remedy. It's supposed to be a very deferential process. But I mean, the concern with this is we're looking at new precedent that kind of partially restores a legal doctrine that had been into effect in the late 40s, early 50s. So we're asking the courts to jump ahead, and particularly when the judiciary isn't across the board. We have problems with some of our judges and their views towards labor.
Yes, this is a longstanding problem, but even worse more recently. We have a good and important question from Mallory in Portland. They say, as I understand it, there's a lawsuit filed against the NLRB's decision in the original organizing case that created the Cemex framework. I recognize that a lot hinges on what the judge decides in that case, but I wonder if that puts the framework at risk of changing in the near future. How stable is a framework like this compared to, say, the NLRB's rules developed through the more formal rulemaking process, like was done with the joint employer rule? So that's their question. And I would just add, how much of this is similarly potentially threatened by, let's say Trump gets elected, there's a new general counsel. What the question is, how stable do we think something like this, how long might this last? Could it last under a Republican administration? What's the timetable one might expect for this? Tony or Ray, do you have thoughts?
I'll defer to Ray on this one.
Oh, okay, fair enough. This case was not, all right, most NLRB case law is developed on case-by-case adjudication, not rulemaking. The NLRB is a little different. So we're used to seeing the changes. I've heard my management adversaries describe it as the pendulum swinging. Question is how much it swings. But that's done in case handling routinely. So the question is supposed to be, how is it substantiated? Is a permissible interpretation of the act? So, and there's supposed to be deference. So if you've heard of the Chevron case, which is under attack, you're supposed to defer. So, I mean, my first thought is this decision came out like we've seen all kinds of other decisions. I know there isn't a action against it. I would not, and if I'm remembering it, it is in the district court. It's in the wrong place. So what should be happening is the appellate court. So if the circuit court overrules Cemex, it's going to get wiped out. The other thing is, and you're right, if the Trump board comes in, the pendulum will swing, and this is going to absolutely be a casualty. I mean, there's no question. But my view is we're in the here and now. I'm urging people to use this as a tool to support what they're already doing and take advantage of it in the short term here and now. My hope is that it disincentivizes unfair practices. So I'll have employers being counseled not to go in and commit some of the more blatant unfair practices, wiping out our organizing department, going the first day or two and starting with threats of plant closure, which, you know, we see routinely. So to me, I'm focused on right now, what can I accomplish? But I agree that as soon as we get a anti-union change, this is going to go by the wayside. Let's remember, the Obama board put in the expedited election rules that kind of sped things up. And under those rules, we won more. We got quicker elections. We were less exposed to unfair practices and anti-union campaigns, and we won. The Trump board shut that down. But we still had our wins. We were still at the table. We still notched our collective bargaining agreements. The Trump board shut it down. The pendulum swung. The Biden board has now given us the speed up. So hopefully we'll be able to take advantage. That's my thought here. I don't want to stand here and look at it saying this isn't going to last forever. So
Gotcha.
I'm not going to take advantage of it. I think we need to take advantage of it and see where it leads us. Use the tool we're given, even if it may disappear by February. And there's no doubt in my mind that if Trump is reelected, this and many other things we're looking at are not going to be around for a while. So let's take advantage of the tool now and use it. But that's just me.
Yeah, as I say, as in with life, so is labor law, that the only constant is change, and our rules are constantly moving about every 4 years, 8 if you're lucky, right? So just organize under what you have now, and worry about the future when it kind of gets here, I think, if that change comes.
Tony, can I ask a follow-up question?
Sure.
Based off of what Ray was saying, is that, so in theory, we should, even if we don't know how long the bargaining orders will take, presumably we should have seen some change in employer practice based on the threat of this, you know, that they know that they're more likely to get dinged the bargaining order for ULPs. Have you seen, or what's your anecdotal or direct impression of whether, in fact, since the new ruling has come down, have you seen fewer ULPs? Have you heard of there being like toned down repression and illegal? You know, what's your impression of the impact it's had already?
I can tell you through third-party anecdotes that employers are understanding the rules, because like Ray can attest to, more RM petitions are being filed, right? So they know they have to file the RM petition. So they're also being educated that, hey, maybe not attacking our workers so much. I haven't, all of the Cemex decisions that I've been a part of or talked to folks about or worked myself were cases that were prior to the order coming out. So these are all backtracked, right? I haven't worked on anything going forward where it's been an issue yet, where I've had the opportunity to file a request for CMEX on it. So maybe that's indicative of management not, committing any ULPs or as much as they have been. So
it'd be an interesting research question, and or for people out there, if people have seen a decline in ULPs and new bargaining organizing drives that they've seen since this is out there. That would, if people can chime in on the chat if you have thoughts on that. But go ahead, Ray.
Eric, so and Tony raises the RM petition. Normally, there are about 40 RM petitions a year. Since CMEX, as of a couple weeks ago, there were 254.
wow.
Meaning employers are out there reacting. So in one of the cases I have going forward, the union organizer was fired the day after we filed the petition. And we had some threats and we had some other things. After that, they got an attorney involved and there were still unfair practices, but we haven't had any more organizers fired. Yeah, it kind of lessened. So I don't know if that's going to apply across the board, but I'm hoping it does, but we'll see. I mean, as employers learn it, they get educated. Hopefully it puts a stop on some of the more blatant ULPs. And if it stops the more blatant ULPs, then maybe we can win an election. So.
Presumably this, amongst many other things the NLRB has done over the last few years, helps explain why major corporations are trying to get the Supreme Court to rule it unconstitutional. So it is interesting because on the one hand, in our experience, the NLRB always goes too slow and everyone loves complaining about it, which because I get that. On the other hand, taking a step back, Starbucks workers appear to be on a step towards the first contract yesterday, and NLRB played an important role in that. So just sort of taking a step back from Cemex in particular, there's a reason why employers want to destroy the NLRB. And so it's this very contradictory bureaucracy we're sort of obliged to engage with. We have I asked other people to put in their last questions. We're coming up on time. Maybe just a very quick follow-up question from Mallory. Asks, what would happen if a ULP is filed now and is sort of in the process pending review for NLRB for a Cemex bargaining order? What happens if the rules change? Does just that whole process just immediately dissipate, or is there some sort of, if you're baked into the system on these types of rulings, then it gets to work its way out? Or does that process, if it's overruled, just everything that happened there, it just goes away? What has been experienced in the past when rules have changed?
Well, Tony was telling you about the application of the rule backwards. So all the cases in the litigation pipeline before the board, if the board changes its rule, go back. If the circuit court, it's kind of a little crazy, but if a circuit court says no, we're not enforcing Cemex, it only affects that circuit court. So if you're in the Second Circuit over in New York and the judge says no, if you're in the Third Circuit here in New Jersey, we still have it and go forward. So if there are conflicts between the circuits, then you wait for the Supreme Court to weigh in. But so that's how that system kind of works. So you're in the process. I mean, from my perspective, what I've seen is once you get into that process, if you're getting into lengthy litigation, some employers don't want to do that. So like I had a case last spring where an employer had a 10J, a GISL bargaining order before a judge, and finally decided they had put too much effort into it. The trial had gone for days and days and just wanted to sit down and bargain. So hopefully we see that while the cases are wending their way. But, to me, this is just a tool to try to disincentivize ULPs and maybe move us along and get us a quicker way to get to the table before our strength is dissipated. So, I mean, I wouldn't put all my hopes or all my hopes on Cemex or its longevity, or let's use it now.
Gotcha, thanks. So one question I have, and this is related to all of the discussion we've had, is that it's not specific to Cemex, but it's connected. Is what actually, in your experience, has happened, tends to happen when you do get a bargaining order? Like, how much in practice, in your experience, has that pressured employers to change what they're doing? You know, if you have a real cutthroat employer, or maybe there's like sort of a middle of the road employer, you know, because that's I just be interested, because this ultimately is like the stick. What in your experiences have bargaining orders done in practice to change, if at all, employer behavior? Tony?
I'd say just I mean, prior to Cemex, it was pretty dang rare to get a bargaining order.
Gotcha.
So I don't really have much reference. I'll have my first one here when we start bargaining this contract. But yeah, I don't know, Ray, a little more seasoned. Maybe you've got some experience.
No, I've had several Gissel bargaining orders. So the problem with Gissel is it was focused on, will you be able to get back your support through the board's normal remedy? So by the time you get a Gissel bargaining order, you're pretty much, it's been years, it's very difficult to keep support alive. So when you arrive at the table, you got an employer looking at you and you don't have support. So if you can leverage something other than support, so you know, effective strikes, picketing, rats, etc., then you can marshal it. So prior to this, when you were talking Gissel, I've gotten a couple contracts, but it's always been where there's been some other incentive. The union's been able to leverage some strength somewhere else. So what the hope is here, you get to the table before your support's dissipated. I mean, think of Gissel is the union can never win at an election because the unfair labor practices have destroyed it. So go bargain. You have no support. That's why you get the Gissel bargaining order. So now you got to reorganize the place following these unfair practices. And then, as the regional director said, they send you into the table to talk. Well, you need to get leverage. So the hope is, my hope is with this, you're getting this bargaining order before your support's dissipated, and hopefully a little quicker. So now you can combine employee support with leverage, strikes, picketing, whatever. So,
Gotcha. Great. That's very helpful. We have a question from Noah, which is, does Cemex have any relation to ULPs committed before you have majority support and before you've filed for recognition? That's the question. And then if not, can you still maybe explain, just for Noah, what recourse one has in that context when you have a ULP before you have majority support? What do you do at that point? Talk about Cemex and then just talk for Noah's sake what you would do in that case, period.
So Cemex is really a case that flows from majority. You have to have majority. So you have to have demonstrated majority status, because the idea is you're encouraging bargaining. The employees have shown majority support. We normally would go to an election, but the board says your majority support's enough. Now, employer, if you have a good faith doubt, file your RM, but don't commit any unfair practices. So in the other case where you're in the bargaining process and you're prevented from getting majority support, Cemex is of no use. It's not a tool that's available. There is some very old case law, it's actually in the Gissel case, where they talk about, and it's too late in the day for me to remember the specific test, I apologize, but it's extremely serious, substantial unfair labor practices that kind of raise the bar. So the Supreme Court said, under those circumstances, you may be able to get what's called a minority bargaining order, but those are extremely rare, and some of the circuit courts don't enforce them, and it's just a very difficult mechanism. So I think when you're in that situation, your best recourse is using the NLRB, asking for 10J relief to try to get your workers back. And the question always then is, when we get workers reinstated to a job site where they've been fired, do they actually want to go back? So how do you get them back? But I mean, that's really your recourse. So, I mean, you obviously have the ability, to me, leverage concerted action, outside pressure tactics, all the other things that union organizing departments do, top down type pressure to try to restore your support. Cemex is not helpful. It's not doing anything where you'd never attain majority.
Tony, then for Noah's sake, Tony, just in your experience, even so, Cemex isn't going to help. But what do you tell people when they're
Well,
pre-majority on ULPs and all of this?
Sure. I mean, context is everything, right? First thing I'm going to ask is, I'm going to consider is what is the ULP and how serious is it, and how much is it really going to impact my campaign? It just goes back to, employers are going to, just reiterate, employers are going to do everything. Their goal is to get you off track of your campaign and talk about or engage in any kind of conduct or actions that take the workers and takes their focus away from their issues and resolving their issues. So if it's something minor or something that's, yeah, it's a ULP, but I don't really think it's going to have that much impact on something, I'm going to log it, note it, and we have 6 months to file a ULP on it. If it's something significant, I may encourage them to file a ULP with the board and seek some kind of relief to neutralize that, right? Whether it be to give the persons their job back if they've been terminated, allowing the union to come in and talk to the workers on company time, right? Any of those things. I mean, the board's creative with their resolutions now. So I'd be seeking something like that if I think it's really an impactful or a ULP that the employer's committed.
Great, thanks, Tony. So we're getting up at time, so I'm gonna throw it back, or actually throw it for the first time to Dejar to sort of wrap us up. But I just want to say that I really appreciate Ray and Tony for you taking the time and digging into all of this. I hope it was helpful for everyone out there. I certainly learned a lot. So we'll give a round of applause digitally to Ray and Tony. Thank you for all of your hard work. I'm going to pass it to Dejar. Thanks, Dejar.
Hi, all. So I want to thank Teresa Poor, who's not with us anymore, and Tony Ruiz, and Ray Heineman, and Eric Blanc for putting on a fantastic presentation, very informative for all of us. So thank you very much from the Murphy Institute at CUNY SLU, from Scontras Center at University Southern Maine, and from Rutgers Learn at Rutgers University. We appreciate everybody who participated and listened. Thank you very much.